All right, so this is a great pleasure to bring home the conversation with Bill Baer, who really does have an extraordinary background to set him up for his current job. He has worked in the antitrust world for how long, Bill?
Well, since the 70s.
I was going to say 40, coming on 40 years, and you also had the benefit of taking antitrust law from Bill Baxter and having Bob Potofsky as your mentor. So not only does he have this extraordinary background, he's also been trained by the very best. So we'll have the chance for a discussion. We'll get some folks involved at the end. I want to start by an important point I adverted to earlier, which is that competition policy is not necessarily limited to antitrust law as enforced by the courts. Could you explain a little bit about your thoughts on that topic?
Sure, but let me first thank you for the invite. It's been quite an experience, as Phil mentioned. I said to him last night at dinner to see the way this debate occurs here, the respect for differing points of view, and the flow down the table, and then the pushback on things. It is an extraordinarily well organized conference, and obviously we've thinned our ranks a little bit, but the way in which your team, the students, have worked to deal with, an unusual weather event, it's just been impressive. All right, but so that's
thank you.
But it is an honor to be here. So, what we do at the Justice Department, my view of it is, it's first and foremost a law enforcement function, and we go after cartels, we go after civil misconduct that is inappropriate. We slightly different, forward-looking view when it comes to mergers and acquisition. That is core to what we do. It's core to what the FTC does. But we need to think about where we fit in time and in space, and that really is, I think, the issue you're raising is how do we think about the right role of antitrust enforcement, given the fact that it is not antitrust enforcement uber alles, which I think was part of the last panel yesterday, the different perspectives on that. We have markets where there may be shortages, where there may be monopolies that have been created by regulation, by scarce inputs, and we need to think about how we enforce the law in those markets. But we also need to think about ways in which we can communicate to people about how to make the market work best, even though there's a regulatory overlay to it. And so you can look to advocacy before the states relating to the medical space, certificate of need requirements, which the FTC and DOJ agree are probably mechanisms that are outdated and tend to inhibit competition. You can think about some other occupational licensing things that the states do that arguably are more to protect the professionals involved in that occupation than necessarily to provide meaningful competition to consumers. We can think about work we do with colleagues at the FCC or on transportation policy, I think you mentioned yesterday, and in intellectual property policy. So thinking about ways in which, by using our expertise to suggest how in a regulated environment competition might be part of the answer to make that market deliver goods and services, highest quality, lowest price to the U.S. consumer.
So one area that's very much in the weeds of this discussion is spectrum and how the market for spectrum is structured and developed by FCC decisions. The FCC recently, for their incentive auction, has limited the ability of certain larger firms to buy more spectrum licenses. How does the DOJ work on those sorts of matters and collaborate with the FCC?
That's a great example of, we do have an FCC regulatory mandate to allocate this new spectrum that's potentially being made available by broadcasters. It's a great opportunity, but we've got a history in spectrum whereby a few incumbents have actually gotten a significant chunk of spectrum, and particularly the low frequency, high value spectrum that penetrates buildings and things. So we've got a situation where there are two really big guys, and they're basically a third to fourth, Sprint and T-Mobile, which have less opportunity to build out than some of the big guys. So as you put this new chunk of spectrum out there for auction, one of the things Tom Wheeler's commission has done is put market screens in so that in areas where a particular firm has a high percentage of the already existing spectrum, they likely will have every incentive to pay the most because it increases their market power. It gives them more opportunity to exclude opportunities for rivals. So we have been an active participant. I think we filed 3 comments in that rulemaking saying, there ought to be a market power screen, and you ought not to take a situation which is potentially problematic today and let the highest bidder make it worse.
So I've got a few different questions in the area of merger review I'd love to walk through with you. First is a tricky one that doesn't get litigated that much, so it rests a lot in the prosecutor discretion of the Antitrust Division, how to think about mergers where 2 markets are at issue and where you may have benefits in one market and maybe incremental harms in another. I'm thinking here about the DirecTV AT&T merger, where some people said there might be some incremental loss of video competition because it was arguably in some parts of the country a 4-to-3 merger where number 3 and number 4, or maybe it was 2 and 4, might be merging. But there were lots of other benefits that would come from it. How, in general, should the antitrust authorities look at such cases? And if there's anything you can say about that specific case, we'd welcome that as well.
Well, first of all, I think we need to look at claims of efficiencies, whether they're in market or out of market, a little skeptically. And let me elaborate on that. First, in merger enforcement, we are making a difficult predictive exercise. And we are, under Section 7 of the Clayton Act, told that we should prevent the accumulation or acquisition of market power and err on the side of incipiency. That is, and so in making this prediction, our key job is to take a very hard look at whether there's the potential for there to be anti-competitive consequences, market power resulting from a particular merger, whatever the products or services at issue. Very often, and our merger guidelines invite people to come forward and to say, but you should allow this merger because there are great benefits. We will be a more efficient competitor. Bill Baxter, whom you mentioned, my antitrust professor, and a very thoughtful, wonderfully thoughtful guy, he thought efficiencies should count for 0. He totally bought into the longstanding Supreme Court case law that that's not the job of the antitrust agencies. And I had a long conversation with him years ago about it. And basically, because they're so easy to gin them up in terms of a claim of efficiencies, of cost saving, it's so hard actually to rely on them. So we try, in looking at efficiencies, first to take a look at whether or not there's likely to be a serious market power enhancement from the transaction. If we think that's pretty likely and it's a pretty significant enhancement in market power, we're going to be highly skeptical of any efficiency claims in market or out of market. Second, where there is kind of a close call on the competitive thing, then we're going to dig more deeply. And we're going to differentiate between efficiencies that past history suggests to us can be realized. In most markets, there's a history of consolidation, and companies often can come in and show us what a trend line is, or show us in the last deal they did, they actually were able to lower overall cost and increase their competitiveness. So, long-winded way to get it. If you can show us those, and we don't have a high level of concern about anti-competitive consequences in a particular market, we will take them into account. The courts say we don't have to consider out-of-market efficiencies when we're litigating, but frankly, if you've got a very minor risk of anti-competitive harm and demonstrable lowered costs from the consolidation, as a matter of prosecutorial discretion, a good antitrust enforcer, I think, will take a really, really hard look at that.
That's helpful. Another matter that you have talked about before is the significance of disruptive innovation, or mavericks, and one case that comes to mind is in the wireless sector, where T-Mobile has undertaken a lot of interesting experiments, and they've been innovative in their marketing and product development. That's a beneficiary of merger policy that's maintained for independent companies in that space. Is that something we can learn something from when and how we see mavericks? And one of the concerns people say is, T-Mobile, for example, is it just that you have this innovative leader, or is it that they're the number 4th player? How do you connect disruptive innovation and mavericks to market structure?
Well, let me first use that example to go back to your prior question. One of the key claims of efficiency from AT&T's failed effort to buy T-Mobile, they gave up when both the FCC and the Antitrust Division said we're going to go to the mat on this one. They said they would never be able to build out LTE to even 80% of the American consumers unless we let this deal go through. And with months after our blocking the deal, or their abandoning the deal, they were basically saying they thought within a short period of time they could build out LTE to 96% of the American consumers. That's one reason why taking those efficiency claims a little bit skeptically is an important thing for us to do. So that deal gets abandoned. What happens? Well, T-Mobile has to go to Plan B. It's too bad that deal actually ever got proposed, because the implementation of Plan B was delayed for about the 18 months in which the deal was under scrutiny. And there is a cost to competition during that period. Mergers under review. Parties have a right to propose them, but it's one of the reasons why I think sellers increasingly are looking for reverse breakup fees, because they want to be compensated for that period of time when they're stuck in this limbo, and it's impossible. I've represented companies where the employees are going nuts. They don't know what to do, and then when it's over, there is really a diminution in the competitive significance of the seller. Usually, the buyer keeps pushing forward. So what happened when T-Mobile had to go to Plan B? They basically, blew up the old format of how you would go to market, and so offered the kinds of plans without the 2-year commitment, other sorts of things. Now they're changing the way data is bought and paid for. It's really disrupted that whole marketplace, and you can just see folks have had to respond. We are benefiting from a degree of competition that didn't exist before. And I'll say that one of the first things that happened to me when I came into the job in 2013 was, this is all public, Sprint's owner came to me and said, all right, you wouldn't let AT&T buy, but why not let 3 and 4 combined? We'll be a stronger number 3. Well, everything we knew about the market, about the positioning of Sprint and T-Mobile, suggested that, in fact, this market could sustain 4, that with the spectrum auction coming up, T-Mobile would be potentially in a position to deal with some of its disadvantages. And there was about a 3-month lobbying campaign where the combination of sort of a steeliness at the FCC and at the Antitrust Division, they gave it up. In the meantime, though, T-Mobile was continuing that down Plan B, and as I said, we've seen the benefits of that.
So one other issue that Antitrust has to deal with is market definition. This is often viewed as a essential foundational exercise it's also a difficult one in technologically dynamic markets. So take two markets that antitrust enforcers looked at over the last 20 years here. One is MCI WorldCom looking to merge with Sprint, where the market being protected then included long distance, even with imminent Bell entry. And part of that was the merger guidelines talk about harm in a relevant market within a 2-year period and not really looking too much beyond it. Another one is XM merging with Sirius, where the merger was allowed to go forward in part because there was a belief that wireless broadband enabling smartphones was going to be a relevant competitor, even though it seemed almost certain at the time that was going to be more than 2 years out. How do you approach this question of market definition in technologically evolving markets?
Well, it's not, the challenge is more frequent there, but it's not a difference in kind from what we have to do in a brick and mortar or service industry merger. As economic tools have evolved, and as we've tried to update our thinking in our horizontal merger guidelines, which were last updated in 2012, you were probably at the front end of that exercise when you were at the Antitrust Division. We've tried to talk about about merger analysis not being seen simply a sequential thing. You define a product and a geographic market, then you look at market shares, then you look at entry. Is it likely to come in a timely and significant fashion? Then you look to efficiencies. Do they offset? The reality is you've got to look at the competing firms, the degree to which they're particularly close rivals, the degree to which a market may be so concentrated that there already is coordinated interaction behavior going on, which was a concern we articulated in our complaint against US Air and American Airlines. That you've got to look at the reality of the competition, and then you look at it today, but you make sure you aren't doing a static snapshot. You don't let yesterday predict tomorrow. You take a look at where innovation is going. And you had mentioned MCI Sprint. I think part of the concern there, indeed in our complaint in that action, I went back and took a look at it, the first cause of action related to the internet backbone. And that in MCI Sprint, combined, they would have about 53% of the internet backbone. And that was the thing that concerned us most. We also identified the issues you raised, and I think at the end of the day, that prediction would have been wrong, that there was more competition as things evolved. So in a high-tech market, I have a tendency to filibuster, but I'll turn it back in a minute, Phil. In a high-tech market, it may well be this sort of convention of we're just looking out 2 years, and our guidelines are more loose about that. We do really want to get it right. We do really want to see where it's going. The further out you look, the harder it is to predict, but it is a legitimate thing to look at in these innovation markets.
So one recent merger that came before you is the Comcast-Time Warner merger. You have been quoted as saying that the concern is that Comcast will be left with too much control and too few competitors when shaping the future of video competition and broadband and internet service. I believe the figure that you or others may have said is post-merger there would have been 60% ownership of high-speed broadband subscribers in the U.S. It looks like that concern is rooted on the merger guidelines stating that a merger that would be likely to create a potential harm to competition, sort of an exclusionary harm, was at issue. What can you say about that case? And then as you think about it, how would you weigh making sort of, call it type 1 versus type 2 errors? As you're thinking about stopping a merger, how much do you worry about, like the MCI WorldCom maybe would have got that one wrong, versus, well, if we didn't stop it, all the harm that could come? That's part of the real challenge in making these judgments from incipiency. How do you approach that generally, and then specifically with regard to Comcast Time Warner? What can you say about it?
Well, let me start with Comcast Time Warner. I was not actually involved in it because I had been involved in a prior matter, the GE Comcast thing. But I've learned some since from what's been said publicly, and as a result have talked about it. We really were worried that having one firm responsible for delivering content, over the wire to 60% of the homes had the potential to distort competition upstream. And it's not unlike, I think, some of the issues that play out in the net neutrality debate. And, you do have this one pipeline problem. And to have one entity with 60% plus of the eyeballs over that last mile did concern us. It would give one entity, Comcast, significant and disproportionate leverage in dealing with content providers. So we worried that this thing would be distortive of competition, and on the other hand, there were not particularly compelling efficiencies offered. This was a great opportunity for Comcast to get more eyeballs, and maybe they would lower marginally the cost of program acquisition, but it was not a compelling efficiency story, whereas we had this concern. Now, going to your broader point, it's unusual, I think, that blocking a merger where we have a plausible or reasonably fact-based story of harm is going to cause long-term injury to a market. I think, that's really what the Clayton Act tells us to do, is be biased in favor of intervention. Let companies compete, come up with the better mousetrap, and grow that way. That the notion that we should be very deferential to shortcuts by acquisition, is really what we try and guard against. So that's kind of basic framework.
So we have a number of students here who are interested in antitrust. As you've looked from the chair you now hold at how lawyers help either oppose or defend proposed mergers, what advice do you have, whether for practitioners or students, about how to be an effective advocate for a particular position?
It's a good question, and I think the hard part about being an effective advocate is appreciating that you're not doing your client or yourself a service if you're only thinking about advocating your position. You can't be subtle and effective, I think, without sort of understanding the other side's perspective on a matter and think about how you'd argue it. It's what moot court teaches you to flip, debate teaches you to flip, and think about the other side of something, and don't be afraid to give the ground that the judge is going to see as already occupied by your adversary. It's not you have to win everything. You really have to suggest that your story, your argument, and I use those terms interchangeably, takes into account the relevant facts, and on balance gets you to a good outcome. There is, I think, also, if you're dealing with the government, I need to appreciate that, you're appealing to our prosecutorial discretion, and to come in like it's a totally adversarial thing where you are going to persuade me to go your way by being two-dimensional, forceful, not concede anything. I've got a whole lot of confidential information you don't, and I'm trying to process it all. You need to get me to want to listen to you if you're representing a private party. And there's a style and tone that comes in that actually, we do learn a lot from our engagement with merging parties, from people involved in conduct investigations, and to come in guns blasting, sometimes at the staff level in particular, shuts down that dialogue. And you want to win at the staff level. If you're in my office trying to convince me not to approve a staff recommendation to go to court, you're already, in kind of a losing position. I may end up agreeing with the parties, but you want to win at the staff level, and that involves a different kind of three-dimensional engagement than some lawyers actually use.
So speaking about the staff, the antitrust division now has staff lawyers, staff economists. Edith Ramirez talked about the FTC developing a staff of technologists and engineers. Can you see a day where the Antitrust Division in different industries, so telecom being an obvious one, other high tech being also notable, would start to not just retain outside experts, but maybe hire technologists to be part of the process?
Yes, I can see that, Dave. We're not there yet. In part, the mandate of the FTC is broader if you get into privacy areas and other things that they probably had an earlier need for it than we do, and we short-term can take care of that need for that insight by using outsiders. But I had a series of meetings the last couple of weeks about how do we do our investigations, and this is where a technologist would help, where we've successfully transitioned from a hard document world to an email and other, and electronic copies of things. But we're also transitioning now to situations where the communications, which often are most revealing of criminal intent or other intent in a conduct investigation or even a merger, they aren't retained anywhere, right? The apps allow you to communicate, and we don't know. So figuring out how we're going to do our job we do, as many of you know, a lot of price fixing investigations. It's about 40% of what the Antitrust Division does, and we work very closely with the FBI on those matters. And we've got great partners over there who are getting us educated on what to do, how to do it. We may need actually to use more covert activity because we're not going to be able to get the email or even cell phone data that we used to get that helps us piece some stuff together.
So as I said earlier, you were extremely prepared for this job. What's been the hardest part of the job for you?
Hardest part of the job was when I came in, January of 13, we had been through a 2-year hiring freeze. We had sequestration. We had my predecessor had closed 4 of 7 offices outside of D.C., but with the promise that anybody who didn't transfer to a remaining office, we'd be able to hire up those positions, so there would be no net loss in bodies. And what happened was those offices were closed, and then the hiring freeze hit. We had our normal attrition. By the time I got there, we were at about 20 to 25% under our typical staff. And to basically keep momentum going, then once we got permission ahead of the lift in the hiring freeze to begin hiring up, to hire, but those of you who've been associated with law firms know that, in my experience, you bring in 60, 70, 80 people, the potential for people to get lost, for individuals, the partners and senior associates, not to invest because there's just too many, it's overwhelming. So making sure as we went through this hiring bubble, and we have hired probably 150 people in 18 months, not all lawyers, a lot of them legal assistants, IT specialists, and economists, but to get them integrated, to get them up and running, to make sure they feel a stake in what we do, understand how we do it, get them trained, get them mentors. That has been the biggest challenge. It's been a great challenge, and I think, when I leave, we will have sort of renewed the talent pool in the Antitrust Division in an unprecedented way. But it's a hard slog, and we need, as managers, to spend a lot of time dealing with them.
When you came into the division, or after you got there and had a chance to get the lay of the land, did you develop any overall goals for your leadership? And as you start looking back with the president's election upon us, are the things you're feeling proud of having been a part of moving forward?
Yes. I came in perhaps with fewer intentions of making mid-course corrections, because there already had been some correction that my predecessor, for whom you work, Christine Varney, had started. And I talked with her as we were talking through the job, and the priorities were, there was a view out there that the Antitrust Division was reluctant to litigate. We needed to change that perception. If you're perceived as afraid, People will be more aggressive. They'll try and force cheap settlements down you in a merger matter. Behavior responds to the perception of how talented the enforcer is and how committed to using it. And so by bringing in a bunch of experienced outside litigation talent together with insiders who've had some experience, we actually, I think, have shown that we're willing to go to court, that we're credible in court. You don't necessarily win all the cases, but nobody has an easy fight against the Antitrust Division. That was one priority that was started before me that I think we've pushed through. We are now, in an average year in civil litigation, mergers and conduct like the eBooks case, we are in court about 4 to 5 times as much in this administration as the prior administration. So that's changed. And I think it affects the way lawyers counsel about the risk of going forward with a particular course of conduct or a particular matter. That's a good thing. Over the long run, that's, I think, very helpful. On the criminal side, I think one of my priorities, which was a little ahead of what they call the Yates Memorandum, Sally Yates, the Deputy Attorney General, really wanted to make sure that in prosecuting financial crimes, white-collar crimes, that we were holding corporations accountable, but going after the most senior culpable officials. And we've actually upped our emphasis on that over the last 3.5 years. We now, on average, when we've got a corporation that we've found guilty of something, they usually plead out, not always, we probably, on average, it's about 2.5 individuals per corporate conviction. So we aren't letting the corporation take the hit and let the individuals walk free. Our average sentence for an antitrust crime, and 30 years ago, an antitrust crime 40 years ago was a misdemeanor. And so we've had to get the courts acculturated to treating antitrust crime just like other white-collar crimes. Our average jail time has gone from about a year, 10 years ago, to 25, 26 months in the last few years. So that was another priority, and we've made progress on that too.
That's great. Let's get some questions, again, starting from students. And I'm not afraid to call in, folks.
Yeah.
All right, Jeff.
Hi, my name is Jeff. So my question goes back to the disruptive innovation idea, and I'm kind of curious, because it's inherently something that we can't know, are you able to qualify or quantify it to some kind of percentage, like there's a decent, like a 20% chance that something's coming in, or is it more just something you think about in the back of your mind and has like a sway on some of the other factors you look at?
Well, it's a good question. So, how do we look at it? Well, first of all, if we're looking at a merger and trying to assess whether or not it's going to limit competition going forward, or the converse, whether there's a new generation of competition that's independent of the merging parties that's going to make this combination irrelevant 2-3 years down the road. We do look to the R&D, to the future plans of the companies. We are able to subpoena documents from folks that are being suggested to us as new entrants. We are looking at whether or not the company being acquired is itself a particularly disruptive innovator, and whether part of the motivation for the acquisition is to get rid of the son of a gun, so that the incumbents will be protected. So it really, our investigative process, there was the question yesterday about whether having a panel of senators, sort of would be a good way of doing it. And I think one of the people on the afternoon panel said, no, actually, the level of investigative work that needs to go into making a prosecutorial decision, whether it's criminal prosecution or challenging a merger, is such that you need to use all the tools, you need to take some time, and then you get to that point where you decide whether the risks to competition are such that we need to call a halt or ask a court to call a halt to the transaction.
Great. Other questions? Dale, and then Bob.
And trust me, neither am I.
I've hypothesized that an indicator of competitive market is the presence of a wholesale market. And just an example, the value, potential value is Google Fi uses Wi-Fi every place it can, but when it can't, falls back to Sprint or T-Mobile, which I assume is getting some sort of wholesale terms. And that innovation might not be able to happen without the presence of the wholesale market. And of course, a wholesale market also encourages an innovation up the protocol stack above it. And I was just curious, you think my hypothesis is correct that the presence of a vigorous wholesale market is a good indicator of the competitiveness of the market, or conversely, the lack of a competitive wholesale market indicates market concentration or market power?
I'm going to be honest, I've not thought enough about the question to actually give you an informed opinion. As I heard you laying it out, it's a sensible hypothesis, and I would go back to, that in determining whether or not to challenge an acquisition in a particular market, if you get down to too few firms, you may not have a wholesale market. And so I would look at it more that way, and trust my economist friends, and we've got huge talent at the Antitrust Division to help me think it through more along the lines of the question.
Let me give one answer on this, which is incomplete, and encourage students to think about looking deeper at natural experiments. In the long-distance market, when it was Sprint, MCI, and AT&T, there was no wholesale market. When WorldCom was the fourth facilities-based entrant into long distance, they started a wholesale market where people began to selling, retail versions of long-distance product, and it actually made a big difference in terms of marketing competition and even some price competition. And so the hypothesis I would offer is the 3 versus 4 debate, which you get sometimes in antitrust law, is one that's worth having, among other things, with reference to this wholesale market question, and definitely deserving of attention. We have another question? Or is that you, Jolie? Or? Joe, we can do Jolie first, and then Bob, and then we probably should wind up after that.
I'm Jolie. I'm a student here, and I have a question that's a variation on the essential facilities doctrine we heard Judge Wood talk about yesterday. Mm-hmm. Does the presence of that idea, at least, if not sort of the more official doctrine, even though it doesn't technically exist, but the official doctrine, affect your analysis of mergers in communications and technology industries, in that somehow these industries are slightly different than other ones?
The answer is yes, and I can explain. I mentioned earlier the one pipe problem. Well, that's today's equivalent of the one bridge problem, right? And so in looking at a market, is there something that is a barrier to the traditional competitive model that we see in most industries? And then how do you deal with that? And, obviously you can prevent acquisition of the next thing that will reinforce the one pipe problem. And that was a little bit of how we were looking at Comcast Time Warner. The question is it when and how to use Section 2, an act of monopolization, to go after it? And that's where Diane Wood was saying, maybe we've gotten too cautious about attacking that dominant firm, and it may be that it's problematic under the antitrust laws. It doesn't mean that you call it something, but you might want to take a look at whether or not it is creating a huge barrier to competition, and something needs to happen in order to promote competition. And that was, in some ways, part of the theory of the AT&T case, way back when.
So given what I said about his stellar participation as an audience member, it's only fitting to let Bob McKenzie get the last question.
Thank you for coming in this inhospitable day. It's really nice to have you here and hear this discussion. I represent Crown Castle International and a local guy here. On your description of the 4 wireless carriers and how the DOJ looks at it. You described spectrum, but I'm more curious about how you look at the market. And if you look at a consolidation of either AT&T and T-Mobile or Sprint and T-Mobile, there's some societal benefit to let them all fight it out and cannibalize each other's market, and that forces cost reductions and it forces price competition. But does the DOJ look at anything beyond that on the market side, or is that just sufficient to say it's just competitive? Is there any other market dynamic that you look at?
Well, I think we look at entry, how likely it is that if you let 4 incumbents go to 3, that there are 1 or more firms out there that can step in and quickly supplant the competition that was there. So, we do try and look at the most plausible stories of how this is all going to play out. And, and where you have a market where a key input is spectrum, and there's not a lot of it floating around out there, you would be more skeptical about entry or other deus ex machina somehow coming in and solving the day.
So I want to thank you guys for coming with us on a snowy day, joining us to finish up a great conference. And particularly want to thank Bill Baer for staying with us and having such a great discussion. Please join us for lunch, and we'll see you back next year. Thanks, everybody.